Hi, my name is Paige and I work at SerpApi. I recently did a small study about the legality of scraping public pages in the United States, and I'm here to share my findings. I'd like to start with just a quick disclaimer. Myself, neither any of SerpApi's employees or contractors provide legal advice. The content of this blog post is for informational purposes only and should not be considered as legal counsel. For any specific legal issues, we recommend that you consult with a qualified attorney. Now let's go ahead and get into the study. You can legally scrape public pages in the United States. The legality of web scraping in the US has been the source of stress and confusion for many people or companies that could use web scraping to their advantage. While the United States does not have clear laws surrounding the subject or a defining line describing the legality of web scrapers, we can use court cases and the precedents that they set as a guide. There are ways to legally and ethically navigate the world of web scraping, and looking at the most important statutes and laws as well as the cases concerning the subject is the perfect place to start. So let's go ahead and talk about some laws and statutes to consider when it comes to web scraping. The first one is the Computer Fraud and Abuse Act, or the CFAA. It is oftentimes what is referenced as the first law that the defendant allegedly violates. We will discuss it in relation to these cases. The CFAA was adopted in 1986 to address hacking. It discusses the idea of authorized versus unauthorized access to a protected computer or computer system. The CFAA makes knowingly accessing and obtaining information from a computer without authorization or by exceeding authorized access a criminal offense. However, the main problem with the CFAA is that these terms were not defined within the scope of the statute itself. Therefore, the interpretation of the CFAA now relies on different precedents, namely one set by the Supreme Court in Van Buren v. the United States, which will later be referenced in this blog post. The second law I'd like to talk about is California Penal Code Section 502. It is often brought up in conjunction with the CFAA because it has similar implications. California Penal Code Section 502 describes the problems and punishments for accessing a computer system, or network without authorization. This includes not only accessing data without permission, but could also be altering data, assisting others in accessing data, or causing damage to a computer system or network. The third and final law to discuss is Controlling the Assault of Non-Solicited Pornography and Marketing Act of 2003, or the CAN-SPAM Act of 2003. The CAN-SPAM Act of 2003 is not explicitly a web scraping law, but it is referenced later in this article, so I'd like to offer a brief explanation. For the purposes of this article, the CAN-SPAM Act of 2003 deals primarily with a large amount of commercial electric mail or email being sent and whether or not the information is materially false or misleading. When the header or body of the text is materially false or misleading or deceptive, the emails violate the CAN-SPAM Act of 2003. Now let's go ahead and get into the court cases that define the legality of scraping public pages. The first one to discuss is a 2013 case called Craigslist Inc. versus 3Taps Inc. et al. In this case, Craigslist versus 3Taps acknowledged that 3Taps was able to scrape Craigslist as it was a publicly accessible website until Craigslist revoked authorization with their cease and desist letter. The most applicable part of Craigslist versus 3Taps is 3Taps' motion to dismiss Craigslist's complaints of violation of the CFAA and California Penal Code Section 502. 3Taps was scraping data from Craigslist and marketing a Craigslist API. Craigslist wanted to stop their scraping, so they sent 3Taps a cease and desist letter and blocked their IPs. The cease and desist letter even stated that they were no longer authorized to access their site and services for any reason. Instead of stopping their scraping activity, 3Taps used new IPs and rotating proxies and continued scraping the site. After 3Taps ignored the cease and desist letter and circumvented Craigslist's IP block, Craigslist sued 3Taps, citing many different claims, one of which was that they violated the CFAA. 3Taps refuted this claim and filed a motion to dismiss this claim on the grounds that Craigslist is a public website. While this is true, Craigslist cited that the cease and desist letter was a clear revocation of authorization, and 3Taps continued to intentionally access a computer without authorization. 3Taps claimed that being a public website, Craigslist could not revoke authorization to access the site. Upon further investigation into the wording and meaning of the statute, the CFAA, the court decided that Craigslist was able to revoke authorization and rested this decision on the precedent set by LVRC Holdings LLC versus Brecca, a case which dealt with an employee accessing a computer and sending confidential information to himself for his own competing business. The court explained that the plain language of the statute indicates that authorization depends on actions taken by the employer. In LVRC Holdings versus Brecca, that was LVRC Holdings LLC, and in Craigslist versus 3Taps, it was Craigslist. Since Craigslist took the action of sending the cease and desist letter and blocking 3Taps IPs, this was a valid way of revoking authorization, meaning that 3Taps did violate the CFAA. The next case we'll talk about is Facebook Inc. versus Power Ventures Inc., which was a 2016 case. At first glance, it may appear that Power Ventures was able to perform actions on Facebook's computer because they had consent from the users, but after Facebook sent a cease and desist letter, Power Ventures was no longer authorized to access Facebook's data. However, this case doesn't necessarily affect just scraping public pages in general. Facebook sued Power Ventures for accessing Facebook user data and sending foreign messages from Facebook's platform for a promotion that they were running. Power allows Facebook users to spread the word about Power through different Facebook action, which in turn sends an email to their friends from Facebook or sends internal Facebook messages, depending on the user's settings. After receiving a cease and desist letter and an IP block, Power found a way around it and continued their promotion, acknowledging the use of Facebook data with authorization. Facebook accused them of violating the Controlling the Assault of Non-Solicited Pornography and Marketing Act of 2003, or the CAN-SPAM Act, the Computer Fraud and Abuse Act of 1986, or the CFAA, and California Penal Code Section 502. The district court originally gave a summary judgment on all three counts, but a later appeals court upheld some of these charges and reversed others. We will be mainly discussing the appeals case as it is the most recent verdict on this case. The first claim to address is the violation of the Controlling the Assault of Non-Solicited Pornography and Marketing Act of 2003, or the CAN-SPAM Act. Although this promotion caused over 60,000 emails and an undetermined number of internal messages to be sent, a large number of messages itself doesn't violate this act. Rather, the question is whether or not the header or body of the text is materially false or materially misleading. In this case, the external emails that are sent from Facebook are not materially false or misleading. Under the statute's definition, who initiated the message matters. Because of the course of actions, it could be Power or Facebook initiating the message, one of which is correctly identified in the header and the text body. Additionally, Power users gave Power to consent to share promotion through event invitations. For the internal messages, they were also not misleading as Power was identified and Power users consented to the messages being sent. Therefore, the appeals court reversed the district court's decision regarding the CAN-SPAM Act. The next statute they considered was the CFAA. First, because of Power Ventures' actions, Facebook suffered a loss of over $5,000 in employee time responding to the issue. Therefore, under the CFAA, they have a private right to action for a loss this substantial. When it comes to accessing Facebook's computers, at first it could be argued that Power was able to do so because Power users, also Facebook users, gave Power permission to access their Facebook information. Therefore, Power was not violating the CFAA. However, then Facebook sent the cease and desist letter that clearly revoked any authorization or permission they had to access Facebook computers. When they ignored the cease and desist letter and continued their campaign, Power Ventures violated the CFAA. The appeals court faced that Power Ventures violated the CFAA. Lastly, we must review the decision on the California Penal Code Section 502. Section 502 addresses liability if a party knowingly accesses and without permission takes, copies, or makes use of any data from a computer or computer network. The same explanation from the CFAA in the preceding section applies to this case, meaning the appeals court affirmed the district court's decision in this case. Next, we will talk about HiQ Labs Inc. versus Facebook Corporation, which was actually a very recent case in 2022. HiQ Labs versus LinkedIn highlights that scraping data that is publicly accessible is legal and not in violation of the CFAA. LinkedIn sent HiQ Labs a cease and desist letter for scraping public profiles on LinkedIn and said that if they continue to do so, it will violate the Computer Fraud and Abuse Act, or CFAA. They also said that they blocked HiQ Labs' IPs. HiQ Labs then sought a preliminary injunction. It made it all the way to the U.S. Supreme Court, but was sent back to the Ninth Circuit Court, who, after re-examining the case, asserted their original claim, granting HiQ Labs the preliminary injunction. They deemed this injunction appropriate as the IP block significantly harmed their business, they did not violate the CFAA or other laws, and it was found that public interest was in favor of HiQ Labs. They asserted that HiQ Labs did not violate the CFAA because all of these LinkedIn profiles were publicly accessible. It's also important to notice that LinkedIn did not have ownership of this information. When it comes to the CFAA and web scraping, authorization is not required if the information is publicly accessible. The idea that no authorization is required for publicly accessible data under the CFAA is in reference to a precedent set by the SCOTUS case at Van Buren versus the United States. In Van Buren versus the United States, the CFAA is clarified in reference to the exceeds authorized access clause. This provision is in reference to files that one may not have access to. If they were to obtain said information, it would exceed authorized access and violate the CFAA. Van Buren versus the United States also brings up a Gates up or down inquiry, which is applicable to this case. This inquiry discusses authorized access. If authorization is required and has been given, the gates are up, granting access. If authorization is required and has not been given, the gates are down, blocking access. However, in this case, as public websites don't limit access, authorization is not required. There is no gate to operate, rendering the authorization not applicable in this case. The fourth and final case we will discuss is Meta Platforms Inc. versus Bright Data Ltd., which was actually decided this year in 2024. Meta Platforms versus Bright Data exemplifies that logged-off scraping of publicly accessible data is legal and did not violate Meta's terms of service. Meta versus Bright Data was an interesting web scraping case that Meta brought against Bright Data. It was unique because while Bright Data was motioning for summary judgment, Meta was cross-motioning for partial summary judgment for breach of contract and tortious interference with contract. So Bright Data collects and sells datasets through web scraping and offers the use of proxies to their customers as well. Two of the sites scraped were Facebook and Instagram, two social media sites, both of which are owned by Meta. Meta alleges that scraping their sites and selling the information is against both Facebook and Instagram policies, and that Bright Data refused to stop their scraping activity when Meta demanded them to. One of the main issues in this case rests on the term user and consequentially use. Meta alleges that anyone who accesses their site uses their data under their contract, while Bright Data alleged that a user would have to become someone who has an account, and that until that account is created, they would not be bound by the terms. It is also important to note that Bright Data had Facebook and Instagram accounts used for marketing purposes when the original lawsuit was brought up. However, as of December 4th, 2023, about 2 months before this decision, Bright Data terminated all Facebook and Instagram accounts. Aside from the accounts that they had, they claim all information was from logged-off scraping, meaning that all data scraped was public and not protected by a password. They say that because of this, it had nothing to do with their marketing accounts, and they were therefore not bound by the terms and conditions in this part of it, as they were not users. This is further supported by a change in Facebook's terms and conditions. In 2009, there was a clause that said, "Accessing or using our site signifies that you agree to be bound by these terms, whether or not you are a registered member of Facebook." This clause has since been deleted. This clause clarifies that Bright Data would have been bound in 2009. However, because it has since been deleted, Meta seems to have knowingly changed their terms to exclude those who access the website or visitors as users. Additionally, Bright Data holds that logged-off scraping couldn't be bound to the terms and conditions, as these terms are accessible only when you're signing up for an account and are actually only hyperlinked. Therefore, by being on the publicly accessible site, you would neither come across the terms and conditions nor be asked to agree to them. Meta also contends that Bright Data circumvented their access restrictions by various methods, including the use of technology for CAPTCHA solving. However, the use of automation for CAPTCHA solving has been proven different from accessing password-protected content by this court in the earlier case, HiQ Labs versus LinkedIn. Despite Meta's best efforts, they were unable to meet their burden of proof that Bright Data scraped logged-in data. Upon examination of the terms, there was some ambiguity, and because of this, both Meta and Bright Data were allowed to submit extrinsic evidence. Meta chose to not submit any extrinsic evidence saying that their terms were not ambiguous. In contrast, Bright Data referenced the 2009 change in terms, a 2009 statement by a Facebook employee that stated, A putative Facebook user cannot become an actual Facebook user unless and until they have clicked through the registration page, where they acknowledge that they have read and agreed to Facebook's terms of use. And a quote from the Help Center saying, "You have to create a Facebook account in order to use Facebook." After examination of the terms of both Facebook and Instagram, the course of action between Meta and Bright Data, extrinsic evidence, and that logged out scraping is not prohibited by the terms and conditions, Meta's motion for partial summary judgment was denied. Meanwhile, as logged off scraping was not prohibited by the terms, the court ruled in favor of Bright Data and grants their summary judgment on breach of contract. After this, the claim of tortious interference against Bright Data still stood. However, Meta has since dropped the case. So now let's talk about how all of this relates to the legality of web scraping at SerpApi specifically. Here at SerpApi, we only perform web scraping on search engines providing publicly available data. The API calls replicate real-time searches with no login or authorization required. In this context, SerpApi's web scraping is completely legal, as shown by these historical cases mentioned above, such as HiQ Labs versus LinkedIn. We are committed to maintaining legal and ethical web scraping practices and providing our customers with peace of mind. This is one reason for the all plan from the production plan and upwards, we offer our legal US Shield. Although web scraping is legal in the US, we provide this coverage in case there were ever any issues to arise. Our legal US Shield would cover any legal questions regarding only the scraping and parsing of data, not the use of said data. We continue to offer this protection to ease any concerns customers may have in regards to web scraping. I used many different sources for conducting this study, and they are all referenced down below to make sure to give credit to the appropriate places. Thank you so much for watching this video. I hope you have a great rest of your day and happy scraping.